and welcome to the onboarding of your Delaware Statutory Trust. My name is Scott Royal Smith. I'm the owner of Royal Legal Solutions, and it's my pleasure to be able to help guide you through our onboarding process here at Royal Legal Solutions. The goals that we have for today is to be able to give you a refresher of the understanding of the Delaware Statutory Trust and how that flows into the overall structure that you've decided to set up and that we've advised you to set up, as well as to be able to have the most important objective today, which is a completed questionnaire. Because with that completed questionnaire, we're then able to start the process of building the awesome stuff that you have asked us to build for you. I'm joined here with Gina Folk, who is going to pose and help us think through from your side as the customer as part of this process. So Gina will be asking us and asking me questions to clarify things from your perspective as we go through. So we very much hope that this will be a educative process for you, as well as being able to help you guide through the big, scary paperwork of filling out your onboarding documents. And I got to tell you guys, you're going to find that this is going to be an easy breezy process for you, and we're going to hold your hand through it through this video and the other support that we have available for you. So I'll go ahead and jump into it, guys, and just refresh our memory real quick about the Delaware Statutory Trust. That way we can go ahead and start looking at making sure our brains are primed and thinking about this. So this is the Delaware Statutory Trust. This is how the Delaware Statutory Trust flows. Sometimes you wish technology was going to work for you in the right way. And then other times you realize that it has a mind of its own. So here we have our asset holding company, which is the DST, right? You'll remember that has the individual child series and the land trust. The DST is de facto anonymous, and we also use the land trust to hold those other assets anonymous as well. We also see on here as this as part of our operating company, which we are going to be talking about as well too. So that way we have a clear understanding of how both of these critical company structures work in conjunction with our living trust. Now, if you don't have a living trust in place, everything will flow through probate court and be exposed into the public record. So for those of you that do have an estate plan and a living trust put in place, ultimately, all of your companies will be owned by that living trust. But for today's presentation and today's onboarding process, we're just going to be focused first on this asset holding company with the DST. So remembering here how some of the functions of the DST work, we have the parent with the individual child A, B, C, et cetera, on the land trust and the assets. And when we acquire any new assets, we're going to simply acquire those assets most likely in our personal names and then transfer them into the new child series and the new land trust after the fact to be able to hold those assets for long term. And most of the time we're acquiring them in our own name because that's what the financing institution is going to give us the best terms on being able to do it that way. Now, our cash, our stocks, other things of that sort that don't have individual liability associated with them, we can either hold those in an individual child series or we can hold them inside of the parent company here. So when we need to move money around too, remember we're able to move money and hold money just by using like electronic transfers or cutting a check, how it comes out here. Remember, any asset that we have that we think there's individual liability associated with it, we're going to create a new child series and the appropriate land trust to be able to hold that asset. And as we said before here, when we're buying new property or we're purchasing more notes or we're acquiring more assets of any sort, we're just going to go ahead and purchase those properties and then transfer them in to the DST underneath the child series and the land trust. We will use the land trust because it helps us avoid the due on sale clause for any of our real estate assets. And we're going to use a warranty deed to transfer that asset into the structure so we preserve title insurance and be able to create our structure without having anybody get angry at us along the way. So that's our refresher here on our DST. And as apart from just now we're incorporating how would this work with our operating company. And if we have an operating company here, this is our parent DST with a child and the trust that holds the asset. The money would flow then to an operating company, which either be your own LLC, or this would be a third-party property management company in an ideal situation. either one of those is going to work. We don't want this to be you personally, because if anything goes wrong here with the rental out of the asset, that means you'll have a personal lawsuit against you, which would harm your credit score and the ability to get more finance. So we think an operating company is absolutely critical for you as an investor, because you must protect your credit score to be able to have longevity inside of this business. So rents will then get paid to your operating company. Your operating company then pays out to your parent for the long-term cash holding inside of the parent entity of the DST. And then ultimately that money is paid out to you as a distribution or a dividend from the Delaware Statutory Trust. That's the nuts and bolts of how it all works together. Gina, any quick questions that come to your mind about the structure as we just went over it, in terms of getting a high-level lay of the land before we start diving into the questionnaires?
Yeah, can you go back to the previous slide where it's got everything on it? That would be great. Yeah, everything there. Let's see. Technology does not want to work. Okay, so here's the thing. I would like to make sure I understand, because there's stuff in here that I don't know that I thought I grasped it, but I want you to go over it again if you don't mind. So you've got all these things like child A, child B, child. What is that? What is that tangibly? Is that one of my properties? Like, what is it?
Yeah, so here with remember, like we have the parent entity, and when the individual children are treated like individual legal entities for liability purposes. So we have this name Child A, Land Trust A, and Property A for representational purposes, to be able to see like, hey, we're scaling you can see how we're scaling these. It's A, B, C, D, etc. as we go through. Now, this child series of the DST operates on its own entity for liability purposes. So that way, if there's a lawsuit against property A, they can only go after this section of the DST. They can't go after any of the other sections. Now, how these are going to be named depends upon how do you name the DST, and also what property we're located, what property we have. So the child will always contain the name of the parent dash series A. Right? That's how we know that this legal entity is connected to this parent entity when we create it, that. Similarly with the land trust, typically if the property is located at 123 Main Street, we have that property held in the 123 Main Street Trust. That's how we're able to make it look like this property is held for an investment purpose whenever we transfer it in using the warranty deed and the documentation around the transfer of that asset.
Okay, so if I have two properties, then I would need two series.
That's right.
Child thingies.
So your first property will go underneath this child and land trust, and then we create a completely separate child and land trust to be able to hold the second property. So that way each property is compartmentalized, meaning that if I sue one of the properties, it can only get to that one property, and that they're also held anonymously because the land trust is an anonymous trust. It's not filed anywhere. So that way we are able to preserve the anonymity at that point.
Okay. And if for whatever reason I end up not having any properties, because maybe I flip them and sell them and right at this moment, but I still keep the parent company for anything that I might want to put in it later, correct?
Yeah. So if you sell the assets, right, now you have cash. Cash gets stored inside of your parent entity here, right? And let's say you reinvest in stocks, great. Your brokerage account now is held inside of that parent entity, because what we don't want to do is have it held here inside of your personal name. Right? It's like rich people don't own stuff, right? Rich people have asset holding companies that are anonymous that hold everything for them. And that's what you're going to do here. Now, when you re-enter into real estate, we're not going to reuse any of these child series that we built before. We're going to create a new child series in land trust for any of those new assets if you re-enter the market or rebuy new assets. Okay.
I think I got it. So this asset holding company is just where I put anything I have, whether it be property, anything that is considered an asset, whether it be properties, whether it be cash, whether it be investments, any of that. Does it matter what kind of
any
asset
type of notes that you might own can also go into this. Any loans that you've made to people, all of those things that we would say were typically considered an asset that you're building in your net worth. If it's critical to your net worth, then it needs to be in an asset holding company.
Okay. All right, that helps, because I thought I understood it, and then I get to listening to this again and I get confused again. So
yeah,
hey,
no worries. This stuff has a lot of moving parts, and just to highlight again too, is this is where we see here on this map, where this is where the traditional LLC is here, right? And these are our retirement accounts. You see how the traditional LLC and the DST are both owned by the living trust here. Now, when we go back to this final document, here is how the money flows. That's what that traditional LLC is. That's the operating company from we saw from the first diagram. This is
where I do all of the banking and financial transactions out of. The other one just holds stuff. This one actually transacts stuff. Is that correct?
Your operating company is going to be your active operations. So if you need a certain amount of capital in there just to do the day-to-day of what's happening, but any long-term holding of cash, well, should always be in the parent.
Okay, got it. I think I got it.
Cool. Well, let's go ahead and jump then to filling out the questionnaires now that we have a refresher of the DST. And the first thing that you should have for filling out the questionnaires should be an email that came to you that has the appropriate questionnaires designated inside of that email. So Gina, if you could share your screen with us looking at that email, we'll see here underneath one of those is called Delaware Statutory Trust. And then you just click right there, right inside of the email. Great. And now we're here into the questionnaire of the Delaware Statutory Trust. So, Gina, if you could fill in just some mock information for us.
Fill in that.
Here. First is just your email, your legal name. Your legal name should be your name as it appears on your government issued ID.
Oh, it's got to have my middle name and everything.
It could, if that's the way that you want it to go, right? So if you go by all three names, it needs to be consistent, right? If you're only going to go by two names, we just want it to be consistent. But it can't be your nickname, right?
Okay. No nickname. It has to be your at least first and last legal name.
Legal name. There you go.
Okay, great.
We'll ask here for your phone number and your gender. So that way we can make sure to have the right contact information with you and also describe you appropriately in the documents. Here's your social security number. You can type in, that's your government issued ID number, whatever that happens to be. Into it. Of course, that's not Gina's actual social security number, but
no, it's not
your actual social security number here to be able to file an EIN documents that we would need to be able to ultimately open the bank accounts. Because to open bank accounts, you need to have an EIN number that we were able to receive from IRS, as well with all of the entity formation documents.
Now, if I'm, because I'm comfortable, I'm comfortable with your firm, but if I was a little bit uncomfortable putting my social security in, what would I do? What would I do? Would I type something that says ask me or something
like that? If you don't feel like you feel comfortable with anything on here, just put ask me, and then what we're going to do is be able to handle that offline in type of a phone conversation or being able to securely be able to grab that information from you and whatever your secure method might be. Now, these pieces that we have here are secure, but we're happy to be flexible to whatever you believe is going to be the right method for you. And that will typically be through a follow-up phone conversation with us about what that's going to be, or otherwise in a one-on-one type of meeting. Now, going on to the next piece here, we need 3 names for your trust. Now, remember, nobody else in the world is going to care about the name of this trust because nobody is going to be interacting with this trust, right? This is just purely for you to be able to have. So pick whatever name you feel comfortable. We just know that it should not be a name that's directly associated with you, right? Because then that would blow the anonymity, right? So don't use your name. Don't use other names that are directly associated with other activities that you do that would otherwise blow it. But otherwise, feel free to pick whatever type of name you want to. Now, the Gina Folk Trust is not okay because we can't.
No. That's what I wanted to put in there, but I can't put my name on anything. Yeah, that's not good.
So it could just be like Sunflower Legacy Trust.
There you go. Just pick a name.
Yeah, it doesn't.
Are there any rules on what it can be or what it can't be, or?
Yeah, we typically just try to stick with like, hey, what sounds normal and natural of a name that you understand what it means, right? Because ultimately, at the end of the day, you need to be in a position to understand what your documents are. So using names that are going to be comfortable for you to like remember and feel comfortable with, that's the important piece of this, right? So if you try to like make up like a robot name with a bunch of random letters and numbers into it, that's not necessary to be able to have the protection that we're looking for. And it's also incredibly difficult to remember what it's associated with. So
now, do I have to put trust in the name, or do I just?
We'll add trust in the name. So if you don't add trust, we'll add trust, but trust has to be in the name ultimately. But here we understand what that means if you leave us the root, and then we can add in the formalities.
Okay.
Next for us is going to be the mailing address. So feel free to add in here wherever you would like us to be able to send any documentation. So your mailing address, we're typically asking for everybody to have like a PO box or a virtual mailbox in association with creation of your Delaware Statutory Trust, because that address has to go on the public records for wherever documentation or mail will be sent in association with that trust. Absent that piece, you could have your home address, although that would blow your anonymity to some degree if you had your home address. Alternatively, the law firm address is able to be used, but we're not able to send you any of your mail there, right? So we prefer to be able to say, if you want to be able to control your mail, you want to get that mail is important to you, then we need a secure place to do that. That's not going to blow your anonymity. That's not the law firm and not your home address. So we ask you to set up a PO box or a virtual mailbox address for that purpose.
But how do I do that? I mean, do you guys do that for me, or do I have to do that offline, or what does that look like?
Yeah, that should be something that's done offline, either at like a UPS store or USPS, one of those document scanning facilities that they have, of like one of those online services that will take in your mail and then scan it to you and send it to you. Those would be your typical options. There's a lot of things that are able to set up online. They're usually pretty affordable, somewhere between $20 to $30 a month. You won't be getting a lot of mail here through this address. And most of the mail that you would get through there, I would typically consider to be non-critical mail for this purpose. So it's really up to you about what way you want to manage that. Most of our clients, though, will set up something where they can have a virtual mail service that scans the documentation and for them.
Okay, so I'll just make up an address here.
Yeah.
But if I hadn't done that yet, could I just put in there like haven't done yet, or do I need to stop, go do it, and then come back?
Yeah. So if you haven't completed that piece of it yet, then fill in that indication that says I'm planning on doing this here shortly, and then we'll go ahead and just continue on.
Okay, I'll just put that down. But okay.
So your home address in here of whatever you believe, like the home address that you want us to be able to use in conjunction with the trust, that won't go onto the public record, but will be contained inside of the trust. For the home address, yeah, we'll need the number, the street name, city and state, and zip code. We also need to know next is about if you're legally married or not. If you are married, then you'll want to include your spouse, any information on a spouse. So here, not married, so it's optional to put in a spouse. There's no spouse, so we can go ahead and just put none.
But if there was a spouse, you need their name, social security number, address, email, and phone number. Is there a reason you need their social security number?
Yeah, because it'll go into our ability to be able to create the trust, especially if we need an EIN number that's associated with both of you as co-ownership of the Delaware Statutory Trust. Most spouses usually want to own their asset holding company together because now it's like a joint asset. But if there's no spouse, we won't need it. So what happens is that actually relates to the EIN number, right? The social security number we have to have is when we get the EIN. So when we list the spouse to get the EIN, they're also going to ask us, okay, what's the address of that person and their social security number? We'll also want their address and email and phone number, because in the event that we need to contact them for any purpose, we want to have that on the ready to be able to move things along.
Now, you said this before, and I just want to make sure I understand. Can you tell me what EIN is, what it means?
Yeah, so you have a social security number, which is associated with you personally. That's also called your government identification number. An EIN number is associated with an entity. So an entity will have its own EIN number. In this case, that's going to be this Delaware Statutory Trust. And then it's going to say, well, that will have its own number. And then who are the people that are responsible on behalf of this entity? Well, that's Gina Folk. And this is her social security number. So now IRS can match the EIN number to a responsible party, which is the owner of that entity, and say, great, now we can know who to talk to based upon Gina's government identification number.
Okay. So how do you keep me anonymous if the government knows who I am and what it's attached to?
Yeah. So the type of anonymity that we're looking to create is the anonymity that's on the public records, right? So none of this information is going to be exposed to the public records. It's all just for IRS purposes. You can't hide from IRS because that's how you end up going to jail, right? It's because now they think you're trying to hide assets, trying to hide money. So we're not trying to hide from IRS. What we're trying to hide from and protect ourselves from is litigation attorneys that otherwise want to try to find out who we are, what we own, how they can serve us, and how they can take our stuff from us.
Got it. Okay. Thank you. Okay. Business partner.
It's going to be a business partner in your trust. So for some of our clients that aren't owning assets just individually or with a spouse, they'll say, well, I actually have a partner and we're going to use this DST to be able to buy multiple assets together. In that case, you and the partner are both entering into the ownership of the DST. And that's where we want to be able to know, it's like, is there going to be anybody else that's a non-spouse partner with you that as part owner here? So in this
it's a non-spouse partner. So it's not, okay. All right. Because if I have a spouse and I've said I have a spouse, the assumption is they're going to be in it with me, but this would be an additional person outside my spouse.
That's right.
Okay.
Is there anybody else here that's coming in that's just like a third-party business partner?
So if I say yes to this, because I have another, let's just say I have a business partner, then I just put their name, same thing, their name, social security number, mailing address, all that. And then on here, I see the percentage of ownership for each partner. Help me understand that. Why do we need to know that?
So that'll happen inside of like the creation of the trust itself, right? So here, if it's you and a third party, right, that comes into it. So Gina wants to go ahead and partner with her friend Sue, that she knew during high school. So we say, great, do you have a business partner? Yeah, I have a business partner. My business partner is Sue. Here's all of her information. And by the way, Sue is going to get 20% of this trust because I'm actually putting up all the money and Sue is the one that's going to be doing some of the legwork as associated with like finding what are the notes or the land or the real estate or making the investments that we're looking to make. And so she gets a 20% equity interest inside of all of the assets of this trust. So that's where we want to know Sue's identifying information and make sure that she's identified as a party associated with any taxable events associated with this trust. And then also her percentage ownership interest. So that way we can detail that inside of the trust document that then Gina and Sue would both sign.
Okay. So I just put all that information in there and then whatever percentage she owns. So let's just call that.
Let's just put it as 20% or whatever. That's what we've been talking about. Yeah.
20%.
Yeah.
Great.
So here we go. 20 and the percent sign.
Percent. And we're good. All right.
Now, when we come in here, this next question is in the name of any co-trustees of your trust, right? So the person that's a trustee of a trust is the one that gets to control a trust, just like whoever is the manager of an LLC controls that LLC. In this case, right, you would say, well, Gina owns 80% of the trust and Sue owns 20% of the trust. Now that's equity. That's how much of the division of what are the assets. It's 80-20 and the division of the money that comes out of the trust. Separate question is who gets to actually control the trust and actually transfer the assets? Because Gina might say, listen, Sue, we're in this together, 80-20 on the money side of it, but I'm the one that actually controls the assets. And I'm the one that makes the buy-sell decisions of what we're doing here, right? Now, if that's the case, then there's no co-trustee. It's really just Gina being the sole trustee, right? Now, if Sue actually is co-trustee that says, hey, it's 80-20 on the division of the assets, but Sue, me and you are going to be both responsible for the management of the trust. Either one of us can make decisions based upon what's going to happen with the buy and sell and assets of this trust. Great. Now Sue needs to be listed as a co-trustee. So in this case, I say, unless you absolutely have to, don't have co-trustees. Co-trustees only muddy the waters about who is actually going to be making the decisions on behalf of the entity. And you want that to be you. If you're like me, I like to be able to control stuff to make sure it's going to work right. But if your business arrangement is that you're co-trustees and that both of you need to sign for any actions on behalf of the trust, then great. This is where you're going to list that person.
And what about, spouses? Like if I had a spouse, they might get their feelings hurt if I didn't put them as co-trustee. Do I have to put them or is that
you don't have to put them, right? So for a lot of the clients that we'll work with, they'll have a spouse and they'll say, well, should I include my spouse as co-trustee? And I say, well, who's actually managing the affairs of the trust? Remember when we either were buying and selling assets, when we're opening up bank accounts, and otherwise doing the affairs, now that person has to be present for every signing, has to be present to do anything, right? Because you both have to do it together. So that makes it operationally more difficult to be able to do anything. So it's better off if you can leave it to one person to be able to conduct any of the transactions.
Okay, yeah, that makes sense. That's good clarification. Okay. So list the name.
So this is where, when we talk about the managing trustee, a successor managing trustee, that means that Gina, when you and Sue got into your arrangement together, you said, hey, listen, I'm going to be sole trustee here, but we're going to own the assets of the trust 80-20, just like we talked about. Now, Sue's going to ask like that. So what happens if you die, Gina? Then now who's going to be trustee of these assets, right? You say, well, great. Well, who's going to be trustee? Sue now is going to be appointed as the successor trustee to manage the assets. Your 80% that you owned in that trust is now owned by your estate or your living trust, right? As part of your estate planning. But who can control the assets? Well, that's Sue. And the reason why we want that to be Sue is because Sue's actually in the best position to know what needs to happen with those assets, not your whoever came in from your estate. The estate gets all of the ownership and benefits of those assets because that's what belonged to you and you intended to pass the estate, but the trustee powers of managing those assets relies in Sue. Now that's if you want Sue to have that power, right? If you want your heirs to have that power to be able to manage those assets, then you need to say who that's going to be, right? And then when you look at your estate planning documents, that's likely whoever is the trustee of your living trust or the executor of your will that will say, I want them to be successor managing trustee in the event of my death, and that they're the ones that are going to take control of these assets after I die.
Okay. And the same thing is like, it's not just assumed that that's your spouse. You have to dictate what you desire for this one.
This needs to be dictated exactly who it's going to be. When we say we make assumptions based upon who it is, that's a default. That still means that we produce and we relist that person, right? So any place we're like, oh, we just assume this is typically your spouse, we have to relist the spouse. If this is going to be anything different, then we'll go ahead and do it in that different way.
So I'll just make this Sue and I'll just cut and paste up here. Maybe I'll cut and paste here. Yep. Okay. But I don't need the 20%, but that's all right. Let's take that 20% out. Okay, great.
Now, here's where we have the trust beneficiaries. Trust beneficiaries are the people that have the, are basically entitled to all of the benefits of the trust, right? So if you have an estate plan in place, right, with a living trust, then your beneficiary for whatever your ownership interest is going to be your living trust, right? So that would be like the Gina Folk Living Trust and as the beneficiary of 80% of the trust, right? And then the other beneficiary would be Sue Great and 20% as a beneficial interest. And those pieces would then be relisted here.
Okay. So if I don't have a living trust though, this is when I assign who I want that beneficiary to be at this point.
Who do you want the beneficiary to be? Or you just list yourself as a beneficiary and it gets passed through your estate.
Through the estate. Okay.
Yeah,
I'll just put my name here and then I'll let that. Okay, great.
Yeah, so I have Gina Folk here is a sole trust beneficiaries. Now, if it here in this case that you also have Sue as a 20% owner, you also want to list Sue into it. So it'd be like Gina Folk at 80%, and then at 80%, and then Sue as 20%.
Okay, so okay, great. So if you put partners in there, like if it's if you put partners in there, you want to make sure that both partners are the beneficiaries. Well, because they kind of probably would be mad if you didn't do that.
Yeah, right. They're not going to want to sign that document if they're not listed as at least a 20% beneficiary.
Gotcha.
And here when we have successor beneficiaries, what successor beneficiaries do is take your place whenever you died, right? So here, if we list a successor beneficiary, instead of the 80%, if we want that 80% of the trust that would otherwise belong to Gina Folk to pass to her estate, we just repeat that information, right? It's a Gina Folk and 80%. If I want it to go to somebody else, right? Like I want it to go to my child, his name is Rob, right? And when I die, I want my 80% to go to Rob, then this is where you would spell that out. I want this to go to Rob. If you have a living trust in place, again, the beneficiary initially would just be the living trust. There would be no successor beneficiary. You would just relist the living trust, because after I die, it's still just the living trust that I want everything to go to.
So if you guys are doing my living trust for me, what do I just put in here? Like the living trust?
Yeah, your living trust will be what you put in there. Your living trust would actually be your initial beneficiary in there. So it'd be your Gina Folk Living Trust at 80%. And then your successor beneficiary will also be the Gina Folk Trust and 80%. Yeah, Gina Folk Living Trust at 80%. Yeah.
Okay. Because you guys are doing that for me. I just don't have it yet. So I wasn't sure which one to put in there. Okay.
Yeah, your name, your living trust is almost titled with always with your name or to your and your spouse's name, and then living trust is like a naming convention with that. So that would be for you as well as for Sue. So Sue would have to tell us how does she want her successor beneficiaries to come. Absent her telling us that, we're just going to relist Sue's name as a successor beneficiary, because that'll just mean it'll go to her estate and get passed through her normal estate process.
Okay. Okay.
Cool. So here we come in too is in transferring the properties or assets into the trust. So what we want to do is just list each of the properties that we intend to be transferred into the trust. So if you're a client that says, cool, I've purchased some property transfers, then this is the place that you want to list those, right? Because it says, please list the address, the current ownership, approximate date of purchase of each of your properties. Now, the current ownership is where it gets into like, well, how is that property named, right? Is it named in just your individual name? Is that named with you and the spouse's name? Is that named in the name of an LLC? How are you currently holding that property? That's what we're trying to get to there. So what'll happen is we'll look at the deed records to be able to say, hey, great. Does Gina think she owns this property inside of her personal name? When we look at the deed records, is that accurate? If that's not accurate, then we need to figure out how can we get aligned on how the true ownership of this property should have been here. Lastly, what we have here is, and that'll be true for any of the properties you have. So if you have 8 properties, we need to know all 8 that would be transferred into there and be listed in that way. Lastly here, go ahead.
Well, I have a question for you, because it says if I have a copy of the deed to send it to you, what if I don't know where they are? Like, I'm sure they're out there, but I don't have a copy of them.
If you don't have a copy of the deed, typically that's going to be in the title packet whenever you close on your property. But if you don't have a copy of your deeds, those can be getting in through the county clerk of whatever county where the properties are located. And we advise to be able to grab them from the county clerk. However, if that's too difficult for you from what it is that you know how to do, don't worry about it. Just give us all the identifying information that you have about the property, and then we'll work on being able to grab that deed. It's going to slow down our process of being able to deliver everything to you, because that'll be an extra piece of work that our team needs to take over, but we can help you with support on that.
Okay, so you can do it. I just need to expect it to be done. Like, it would just take longer for my thing to get finished because they're waiting on the deed. So ideally, it would expedite my process, like not, more than you getting the deeds for me if I got them to you.
That's
so
right.
I would just scan those to you. Okay.
And that's going to be true for any identifying piece of property, including if you have any notes that you own, right? It's what are the copies of the notes? If you have hard money loans that you made, it's copy of the hard money loans. It's anything that's a critical asset that we're moving into the DST, including any type of real property. Those are the types of identifying information in the list of assets that we're looking to gather here.
Okay. All right. And is that it? That's all we got on this?
That's it for that page. We'll just go ahead and go down there at the bottom. We say here, is just want to remind everybody that this is part of our process that we have for the questionnaires. And we ask the questionnaires to be completed within 30 days because that's the only way that we're able to deliver on time from you, from the time projections that we gave you when you asked us, how long do you think that this is going to take us? We also have a 14-day return policy. That's our window to be able to say, hey, how do we reverse course before either one of us get too invested in this project and we spent too many resources to be able to abort, right? So we have that 14-day window that's here, and we have included this in the form just so we're all clear about how are we going to play together nicely on being able to make sure that we are able to adjust course if we need to, but not get overly invested before we have to change course. So we just ask that you acknowledge that by agreeing to the policy that we have here, and then click submit.
And if I wanted to get a copy, I'm not going to do this right now, but if I wanted to get a copy, I just click this button right here and I would get a copy of my responses just to remember what I said.
That's right. Just so you have that as part of your records in case it comes up.
And then when I hit the submit button, that
Cool.
would go to the team to deliver.
Yep. So that now is part of like the team, and the team's next step is going to be in reviewing those questionnaires to ensure that we have complete and accurate questionnaires, which is our goal for that onboarding. Now, one of the things here that we come into is saying, like, if this is something that you're filling in on by yourself, that means that it's your responsibility to know what are the questions that you didn't have the answers to and get that to the team as soon as possible. Like, we're looking for that to be able to have within 24 hours, can we get at least initial answers? We can always modify after the fact for anything that we don't have perfect, but we just need to have the initial answers of what it is that we need to put here so we can get the bank accounts established and the entities formed so you can get protected as soon as possible.
Awesome.
Now, coming back into this, so now that was for our DST. Now, the DST is the asset holding company, just like we talked about before. And remember, we talked about the operating company, which is that separate LLC that we had put in place. You guys will remember that the operating company turns out to be, it's this piece of the puzzle, right? It's this, what's this separate LLC that serves as our face to the world here. And what we're going to do is we're going to go through the exact same process that we did before, but we're going to do it for an anonymous LLC, which is our typical structure that we use for the operating company. So Gina, if you can pull back up the email, we can show the email about where is that questionnaire located and how is that titled. So you see here, we look back at our email and we say, hey, great. Our operating company is typically an anonymous traditional LLC. If you did it as a non-anonymous traditional LLC, remember that's going to be the link that's right below. Today, we're going to go through the anonymous version that's a little bit more complete. And that way you'll be able to, if you have the traditional LLC and you have the non-anonymous version, don't worry, the forms are almost exactly the same. So you're just going to get a little bit extra education about how anonymity would work into it, but we'll answer all of the same basic questions. So again, we have the email, we have the legal name that's associated here. We have a phone number, we have the social security number. As we come in to it, those are typically how we have to get the EIN number for that, be able to establish a bank account for this operating company. Again, our next question here is providing 3 names. Remember, our names here is for the operating company. Those are going to be the names that we're going to operate through and be our face to the world. So this is the name that people may care about more because, hey, this is the name that people are going to be interacting with. But I have to tell you, then nobody in the world has lost money because of the name of their LLC. The reason why is because if you pick the wrong name for your LLC for any reason, all you do is file a DBA for $15 to change the name that you're operating under and have a different branding with it. So my suggestion is always, let's go and get it done and then worry about how we're going to dial it in later on. So we ask you to pick 3 names for any of the entities we form because most common names are taken. So we want to be able to use these names, have these names in case your first or second option is taken. We'll be able to have that extra option. Also wanted to point out is that we'll try these in order of that you have them listed. So if your first priority for it should be listed first, second priority should be second, third priority should be third.
So is there anything are there anything I need to be careful of when I'm putting these names out there?
Yeah, so typically we have some pieces in here about like, hey, want to be able to use names that aren't directly associated with you, especially if this is an anonymous operating company. So don't put your name into it. Otherwise, there's some naming conventions that we have listed here about like, hey, this is what you name, should not start with the same 2 words that were here, and we don't want any personally identifiable information. Yeah, so my dream is perfect, right? And we just go out through and list like 3 quick names. Now, if you can't think of 3 names, just list 1 name into it because that's the best you can do right now. Remember, it's more important that we have a completed questionnaire submitted to us than it is that we necessarily hit it perfect. going with it. So if you can only think of one, just list one. But if you have three, that's going to make sure that we're able to get your order done as quickly as possible. Because if your first name's taken, we don't have to get back in touch with you to figure out what a second or a third choice is going to be. So we ask that just please list three when you get to this question.
Where do you go? Like, is there something I could do in advance to make sure that my names are okay? Like, is there somewhere I should search before? Or
yeah, you can go to the Secretary of State website for whatever location that the LLC is going to be filed. For us, it's typically either in the home state where the client's located, in Texas or in Wyoming. And you can search those Secretary of States as what's called a name availability search. And typically it's either free or like $1 to run that search. And that would be able to tell you whether that name is going to be available ahead of time.
Yeah, and sometimes it's called a fictitious name or something like that.
Yeah,
I think in Florida it's called.
It also be called for like DBAs, right? Sometimes those will be called fictitious name searches as well. But for the names of the LLCs, that's going to be through the Secretary of State and looking at the name availability search in the Secretary of State.
Okay, great.
So here at this next question, what we're asking about is what business will it conduct? Well, we have to list in terms of what is this LLC going to be used for. It's one of the required fields when we apply for the EIN number. So we need to list something in here. Honestly, it doesn't matter to me what you list here at all. And to it, it's just a place that we need to be able to include that for IRS purposes. And IRS just tracks to see like what types of businesses are people opening. And so we have to put something in there. So we ask you about it. If you don't know what to put, just put property management.
Okay.
And what state should we file the LLC? Now, typically this is either going to be your home state because you're going to be operating some type of active business inside of your home state, or we would typically otherwise use Texas or Wyoming because those states have the protections that we're looking for, as well as the ability to create the anonymity that we are also looking for. Now, it's to be noted here that in the default is our options are to use Texas because Texas doesn't charge any yearly fees, and it gives us all of the protection and the anonymity that we're able to create with it. So the default here, unless you have a particular desire to have a Wyoming entity or have the entity formed in your state, would just be to leave it blank, and then we'll go ahead and file that in Texas. Important thing to note is that if we form the LLC in your home state, that you're going to be responsible probably, for what I've always seen, is that it's almost always more expensive in terms of the upkeep and maintenance, which is one of the reasons why we typically use a Texas or a Wyoming entity. Now, you only have to have an LLC formed in your state if you're either A, going to own property in that LLC directly in the name of the LLC, or you have like a brick and mortar store. Anything else that you're doing in your life, the LLC can operate and be owned and established in one state and operate among any of the states without registration. Think about it in the fact of like what happens with people buying products online, right? They're buying a product, it's from a company. Does that company now have to be registered in every place where somebody is buying the product? No, of course not. Same thing with that company being able to collect rents and otherwise be able to be an intermediary between you and the rest of the world. So if you're owning assets directly in the name of the LLC, or you plan on opening up like a brick and mortar store, you need to form that LLC in your home state. Otherwise, I would say leave it blank and form it in Texas and save yourself a few bucks.
Yeah. So if I put Texas in here, if like my home state had filing fees every year, Texas doesn't have a filing fee every year?
Yeah, Texas doesn't have any yearly fees associated with it for like the upkeep and maintenance of the LLC. So cool. Yeah, so you're able to save a little bit of money. I think Wyoming has like a $75 charge. Some states like Nevada have like $600 plus that goes into it. So it can really be expensive to do that, and depends on a state by state basis.
Okay,
great. So here is where we talked about where do we have an agent trust. And remember, the agent trust is the entity that will be the listed owner of the LLC. So to make an LLC anonymous, that LLC is as with a listed owner being the agent trust. Agent trusts aren't filed documents, and so people can't find out who actually owns that trust. And anything associated with that trust or the underlying LLC all ties back to Scott Royal Smith and Royal Legal Solutions and our office address. That way we're able to preserve the anonymity associated with both the creation of the LLC as well as the agent trust. Now, trusts have to operate with who controls a trust. And that operational capacity is found inside of a trustee. So the trustee is the one that controls the trust, and the trust is technically the owner of the LLC. So in this instance, and for all of our clients, the agent trust trustee is the client. So here you would just list your name because this is your personal operating company, and to just list your name there. Now, importantly, you may have a spouse or you may be in a partnership. And in that case, you would both be listed as the trustees of the agent trust. But remember, whenever we list multiple people as trustees, now those people have to both be there for anything that trust is doing, which can be an operational nightmare. So we recommend just having one trustee. Now, coming here next to the beneficiaries of the agent trust. The beneficiaries of the agent trust are the people that are entitled to the assets or the benefits of that agent trust. Now, so as you can see here is that the beneficiary of the agent trust is equivalent to the member of a traditional LLC. They both relate to what we typically think of as ownership or equity, right? It's like who's entitled to the assets of this or the underlying interests, or property interests here. So in this case, you are the initial beneficiary of the agent trust as well, because this is your company.
So do I put that, I list myself as the beneficiary?
Yep, you list yourself as the beneficiary.
Okay, now, because I'm putting my names in here, how is that keeping me anonymous?
Because your name is just going to be in here, and that's going to be inside of the internal trust document. None of this will be, none of these trusts are actually have to be filed. So none of it's part of the public record. So these will all be private until the moment that we have to show those documents to be able to prove ownership to a bank or otherwise as part of like an estate planning process. And all of those would be private disclosures that don't get put onto the public record.
Okay, so just so I'm clear, can you just remind me, like, what is the agent trust again?
So the agent trust is the trust that controls the LLC, right? Okay. So when we look at, we have on our one hand, we have our DST, right? Which is our asset holding company. That's completely separate. That's on that right-hand side of the diagram. On the left-hand side of the diagram is we have that traditional LLC that's owned by the anonymous trust. And that's the anonymous trust there is purely to be able to replace the ownership name on the LLC, because the LLC will say, well, who owns this at some point? We want to say it's an anonymous trust that nobody can tie it to. That's how we're able to own the LLC anonymously. Then we have to say, we have to detail inside of the agent trust document as who is actually the trustee. So how can we know who gets to control that trust and ultimately control the LLC? And then we also have to know who's the listed beneficiary. Who do we want all of the assets to go through for that LLC, right? And ultimately, that's always going to be the client. Now, there's other ways we're going to move money around to say, great, well, we really want the money that's going through the operating company to really get paid out to the DST. I understand the flow of money pieces, and we're still going to operate that way. This is just purely for how do we fill in the trust documents. So don't think that this necessarily has to be exactly what the way that our operational business is going to work. This is purely for filling out the trust documentation.
Okay. I think I got it.
Great. So our next piece here is our mailing address, which is the same discussion we had before, which is, hey, we want to be able to not list ourselves or as our home address, because that could blow our anonymity on the public records for any place that we want to receive mail on behalf of this entity. And then also you don't want to list the law firm address because we're not set up to be able to process that mail bulk. So what we want you to do is to set up a PO box or virtual mail or some type of service where they send the mail to that address and scan it to you and send it to you. There's a ton of them. It typically costs somewhere between $20 to $30 a month and to go that route. Most of our clients will use a PO box that has a scanning service associated with it.
And you can just get those
you can get on online right now, right?
Post office.
Yeah, they're so easy to get. You can get online. You can even, like, if you were filling this out at home, you're like, oh, I haven't set that up yet. That's great. Pause the video, go sign up for it, and then fill it in. And that way you don't have to come back to it.
Okay, great. And then our home address, that's just for.
That's the home address, is just to be able to have that as part of the document. It helps us identify, who you are and what that home address is going to be.
Okay.
And lastly, here, when we look at our, lastly here is that we just have our return policy or our refund policy that says, great, to be able to accurately deliver this on time to you, we need these questionnaires completed within 30 days. And then you also understand that with that, outside of 14 days from the time of order, we're already so invested inside of the creation of these documents that we're not going to be able to issue a refund. It's just a way to be able to be fair to each other, to give you enough time to say, hey, if circumstances change for you before we get too invested down the line. Awesome. And then if you want a copy of your responses, you could go ahead and click that send me a copy. That'll send it to your email. Otherwise, you can click submit. And now you have successfully completed your questionnaires for the Delaware Statutory Trust, as well as your operating company here with the traditional LLC with the anonymity. And that's everything that we're going to need in terms of that company structure for you for the DST and your traditional LLC. If there's any questions that you have regarding any areas that you had to leave blank or anything that you felt insecure about, what we want you to do is to be able to email us at support@royallegalsolutions.com and ask us those questions about, hey, these are the areas that I was unable to fill out.
Awesome.
Any final words, Gina, before we wrap?
I don't think I have any. Thank you so much. That made it easier for me to fill that questionnaire out.
Awesome. Thank you, guys.